Hi everyone, welcome again to today's EVICT seminar. My name is Emma Sivna and I'm a third year PhD student at the EVICT project at the University of Groningen. Today we are joined by Dr. Caroline Hunter and Dr. Kate Colliver from the University of York, who will present their work titled Criminal Landlordism and Housing Justice in England's Private Rental Sector. Dr. Hunter is a professor of housing law at York University. Her research focuses on the boundaries between law, policy, and practice, particularly in housing policy and law. She is the principal investigator of the Housing Justice Work Package in the ESRC-funded project titled Understanding Criminal Landlordism in the Private Rental Sector and Co-Producing Solutions. Dr. Kate Colliver is a research associate at York Law School. Their research interests include the relationship between local authorities, housing policy, and social inequalities. They are responsible for the day-to-day delivery of the Housing Justice Work Project in the ESRC-funded project, Understanding Criminal Landlordism in the Private Rental Sector and Co-Producing Solutions. So thank you both for being with us today. We're going to have the presentation for around 30 to 40 minutes. Following which we will have some time for question and discussions. So whenever you are both ready, the floor is yours.
Thanks very much, Emma. Right, so I'm going to start and then Kit is going to take over and then I'm coming back at the end, just so you know what's going to happen. Before we start talking about the project, I thought it might be helpful, given we've got an international audience, to say a little bit about the private rented sector in the UK and England in particular, which has gone up hugely, although you don't see it quite so much in this on this this slide, but essentially being dead almost in the mid-late 80s, it's grown and grown so that it's now bigger than the social sector and has become much more where homeless people are placed by local authorities and where people are at the bottom of the income curve are living now rather than social housing. So it has become much more important in terms of thinking about how it's regulated. Move on. So Emma's already said something about the project, and I won't say anything more about what it's called, which is way too long. But just to say a bit about it, our focus is mostly on Yorkshire and Humberside, and you can see where that is in England a bit from that map. But we'll also have some elements which are England-wide. The work package that Kit and I are working on has a number of elements. And what we're doing today is our case file analysis and interviews with staff who work in local authorities. For each case, we've both got the files, then we've interviewed the officers involved, and we're now doing the second round of interviews. So we're looking at over time what's happening to these cases. And for this bit of the talk, we're really looking at the cases that are to do with illegal eviction and harassment, of which are 5 of our cases are on that. We're also going to use a little bit of our statistics, which are England-wide, but only a tiny little bit because we've only got permission to use a tiny little bit of it so far. And I'll say a bit more about the judges and what we're hoping to do next year about that. Okay, so that's just to give you a bit of a insight of what we're planning, the data we've used for this paper. I thought it would be helpful to say a little bit about the legal context and how in England these things are regulated. So the first bit of law that we're looking at here is the Protection from Eviction Act 1977. And essentially, this says that all evictions from residential properties must be lawful. That means there has to be a court order. And if there isn't such an order, then it is a criminal offence to unlawfully deprive a residential occupier of his or her occupation, and also to do an attempt to do this. And if that happens, it's for the local authority, not the police, which is, we'll see in a minute, is important, to prosecute the landlord or their agents. So that's the first bit of law. The second bit is the Housing Act 1988, and I guess lots of people will know in England, it's very easy to evict tenants in the private rented sector. Essentially, once you get beyond the fixed term, which usually is 6 months or 12 months, then the landlord just has to give a notice, and then it goes to court, and you don't have to give any reasons to want to evict the tenant. So there's no fault in this. When that act was brought in, there was concern that those who were already tenants whose rights continued, they weren't given less rights, that there would be more unlawful eviction. So Section 27 actually creates a reason or a basis to evict through civil action by the tenant if you are unlawfully evicted. The damages which you get if this happens is the difference between the property with and without the tenant living in it. So if you have a lot of security, that can be quite a lot of money. But as time has gone on, this is usually not used a lot, because if you have no security in the property, essentially the difference between you in the property and without you in it is quite small. So the damages tend to be very small. There are some sections which now make it very more difficult to evict if it's a retaliatory eviction, but we won't worry about that too much. Moving on, the other bit of law I wanted to talk about is the Housing Act 2004 and the changes that were then added in 2016. So essentially this requires local authorities, and this is what we're really looking at, what local authorities have to do, is they have to, they should take action if it comes to their attention that the property has hazards, and there are a whole set of notices that have to happen. They also have to have licenses for HMOs, so larger properties that are not lived in by families, And they can choose, but they don't have to have, is selective licensing for other areas where there are particular problems. And if the local authority thinks those things have not been done, there isn't a license, or there a notice for a hazard has not been kept to, then there are criminal offences for failure to comply. From 2016, there was an alternative, which is the civil penalty notice for those offences. Another thing that was introduced in 2016 is what's known as a rent payment order. And this is a tenant can apply for this if there has been a criminal housing offence. So that might be under the 2004 Act, but also covers the 1977 Act, so that the tenant can then apply for to the tribunal to get their rent back if there has been such an offence happening. So that's just to give you some context of the law, of which there's an awful lot. So just to then recap, if you're thinking about civil proceedings, i.e. the tenant taking action because there's an illegal eviction or a harassment by the tenant, there's a range of action that can happen. The tenant can go in contract for an injunction or damages. They can go for damages under the 88 Act, and they can go for a rent repayment order. But in order to do that, they have to show there has been a criminal action at the criminal standard of proof. And for all of those, there are huge problems for tenants in terms of not knowing what the law is, getting help and getting legal aid to pay for it, and also the time. If you've lost the home, actually this isn't one of your most important things. It's usually finding somewhere else to live. On the other side, actually, you might say it's easier if it's for the local authority to take action, to say that something has to happen. And this might, and obviously that can happen under the 77 Act, but this is a criminal prosecution that leads to particular issues about the standard of proof rather than the civil standard. And there has to still be a complaint of wrongdoing from the tenant before the local authority is going to be able to do anything. And we're going to look at that a bit more in a moment. In terms of trying to think about what's happening here, oh, sorry, I've gone too far. I find it quite helpful to think about this enforcement pyramid, and this is being used by Harris and colleagues based on this pyramid, which was originally suggested by Ayres and Braithwaite, to think about what local authorities can do. And we can see under the 77 Act, it's right at the top, civil penalties. But the thing that doesn't really help, I think, for me in thinking about this is this kind of pyramid is only about what the local authority does, and it doesn't look at what on this other side is about what the tenant might want to do and the civil action. But I think it has some help to think about what's going on here. Right, I'm now going to stand down and let Kit carry on.
Thanks, Caroline. So what I'm going to do is I'm going to run you through a couple of examples from our data to give you a flavour of protection from eviction act cases, in particular in practice. I'm conscious we've got an international audience today, so I'm going to read the case summaries in full for you. The first one concerns an attempt at a no-fault eviction. So a tenant contacted the Housing Solutions team, that's the homelessness team at the council, because their landlord had left a voicemail saying they'd changed the locks. And that was after a Section 21 notice, a no-fault eviction notice, had expired. And the tenant reported to the council that the landlord had removed her and her child's belongings. They were out in the rain. And it transpired, however, a little later on, that the landlord believed that the expiry of the Section 21 notice meant that they could evict the tenant that day without a court order. So what the local authority housing team case officer did is they took a statement, they gathered supporting evidence from the tenant, they wrote to the landlord about the allegations, and then the landlord later responded with an alternate account of events, claiming that the tenant had already vacated the property. And what happened in the end was the case was closed without further action because the case officer had lost contact with the tenant. But the first thing I want to note then from this case is it's not worth the local authority's effort trying to chase up a case where the tenant has lost contact, even if at the beginning they're fairly sure that an illegal eviction has taken place. And I thought it was quite interesting doing the second round of interviews for this case, because the first case officer we spoke to was very committed in pursuing it. But a follow-up interview with a different case officer suggested the housing team had actually applied some normative judgments here in justifying their reason to close the case. And these included things like attributions of tenant motivation, suggesting she'd only got in touch with the council to get social housing through them. But they also highlighted some of the practical difficulties created by the landlord contesting the tenant's claims, and then the challenge of losing contact with the tenant. They couldn't take those contested account of events back to the tenant. And the case raises a couple of policy and practice questions for us. So, for example, if the landlord was telling the truth and the tenant had vacated the property, does this necessarily mean that the tenant hadn't been subject to an illegal eviction, given that the landlord had gone in and changed the locks based off of the Section 21 notice expiring? And how narrow or holistic was the council's response, particularly in relation to the tenant's rights? So, for example, did the council help the tenant take any action in relation to the property damage that she reported? Was she supported to report that to the police? Now, it doesn't look like that was the case. So this is case one. I'm going to move on now to case two, which is about unlawful entry and destruction of property. In this situation, a tenant family, so they had two small children, were out of the country when they got a call from some neighbours that the landlord had entered their property, removed their belongings and was burning them outside. And in actual fact, a large crowd from the local area had gathered around to protest this turn of events. So police did attend at the scene. But rather than addressing this property destruction and unlawful entry, the police stated it was a civil matter. They didn't make arrests. So when they returned to the country, the tenants, they found their house in disarray. They found their property missing or destroyed. They did subsequently report this damage to the police, who, upon this report, did go on to pursue issues of criminal damage, arson and theft. And the tenants later contacted the council case officer to specifically pursue the Protection from Eviction Act case. And with this case, the case is ongoing. What the local authority is doing at the moment is trying to pursue the Protection from Eviction Act offence, but that means chasing up witnesses. And this is actually one of the core themes in a lot of this is it's not only the tenants who are witness, but in this case, the tenants were out of the country, so they need to try and locate people who were there on the scene. They're going to be dependent on the police to access some of this information. And it's interesting, right, to note that the police did not initially treat this case as criminal in any respect. They only pursued criminal charges at the urging of the tenant when the tenant returned. Moving on to our third case, and this is a double part slide, so bear with me. This concerned a landlord who partitioned their property whilst the original tenants were still living there. What had happened was, following a disagreement with their managing agent, with whom they'd had some kind of a rent-for-rent arrangement, the landlord presented at the property and informed the tenants that inhabited it that they must leave. And this actually happened repeatedly over the course of a week. So there was, in the first instance, harassment going along here. But around a month later, the tenants returned to the property to find the locks had changed. They called the police, who did attend, who did not attend in this instance, but they did correctly advise the tenants that the landlord had committed a criminal offence by changing the locks. and they advised the tenants that they were within their legal rights to regain entry. So the tenants sorted that out themselves. They employed their own locksmith, they gained re-entry. But the next morning, the landlord and the landlord's associates, so there was a small group of people, arrived again at their front door, forcing entry by removing a front door panel, in fact, and again began to throw out the tenant's belongings. So at this point, both parties, both the landlord and the tenant, called the police. The landlord's police understood that the landlord had intruders. And so the police, acting on behalf of the landlord, came along and told the tenants they had to leave. The tenants had to explain what their experience had been and actually show their tenancy agreement to the police before the police spoke to the landlord and the landlord's associates and told them they had a couple of hours to leave the property. What happened was most of them left, but the landlord left one associate. The role of this person is a little bit unclear, downstairs in the front room. And they'd actually fitted a lock to this room at the front of the property. And the associate continued to occupy this part of the property at the same time as the tenants continued to reside there. So this case is ongoing. The local authority is getting to the stage of having obtained witness statements and supporting evidence. And when we last spoke to them, they were just about to invite the landlord to an interview under caution. As I understand it, this has been a little delayed because the local authority found out that the landlord was taking the managing agent with whom they'd had the rent-for-rent agreement to court. So it's possible that the local authority was waiting to see how that turned out before pursuing legal action themselves. So there's a lot going on in this third case, right? It looks like there may have been a rent-to-rent situation going on in the background, with the managing agent taking on more than the usual level of responsibility around tenanting the property. It raises all sorts of issues about who was actually in charge of the property, who was under whose control it was. And it involves deprivation of the right to the property, or at least that front room, and an ongoing experience of intimidation and harassment, because leaving somebody to live downstairs in your property is obviously an act of intimidation. But the tenants continued to live there, which is also a little unusual, perhaps, given all that they had been through. So moving on to kind of take away some themes from these situations. These three case study vignettes are all taken from a local authority that is very proactive in pursuing illegal eviction cases. And in fact, it has pursued more cases than any other in the UK over the last 10 years. And so it's therefore worth highlighting that whilst these might be typical in the types of things that have happened, it's not necessarily typical that the local authority does manage to get involved in them. So it might be useful here to contrast how the local authority did take on these cases with another local authority in our study that had a very hands-off approach. And they said, well, they send a standard advisory letter for landlords about how to pursue a legal eviction, if that comes up. And if they are contacted about an illegal eviction, generally speaking, they don't deal with it themselves. They refer the tenants on to the local Citizens Advice Bureau, who have been contracted to deal with that on behalf of the local authority. So it's very hands-off. And taking the cases at a very high level, then we can draw out some themes. Generally speaking, we're seeing a tenant who's been victimized in some way, either by being illegally evicted or subject to severe harassment by a person in control of the property. In all of the examples I've just described, that's been an individual private landlord, but that's not necessarily the case. It could also be a corporate landlord or a managing agent, for example. And it's not always clear what motivates these landlords. In some, it's a simple matter of misunderstanding the law. For example, they've successfully served Section 21 no-fault eviction notice, but wrongly assumed that once the time period has expired, they have a right to regain possession of the property. But in others, they maybe believe that the tenant has abandoned the property. And in a portion, like with the third one, it's a little difficult to imagine what justification they have for their actions beyond a belief that their status as the property owner supersedes the rights of anyone else with an interest in the property. Often then the tenant's first recourse is to contact the police, and unfortunately they aren't reliable in these cases. It's been common that they have incorrectly responded, it's a civil matter, and declined to intervene. And so yes, it may not be a police matter because the local authorities hold the relevant powers here, but it does remain a criminal offence. So there is a misunderstanding of the law within the police. And we've also come across instances, as in the third case study, where police have attended, but they've supported the landlord, not the tenant who has been subject to the offence. So given the police's ignorance on the law here, perhaps it's unsurprising that tenants themselves don't seem aware of what they can do. And if they contact the council, what happened, maybe after they've become homeless, There are questions about, whether they manage that at all. How then do they get involved? If they do get involved, if the council get involved, does the tenant have the confidence to pursue a prosecution, and does the council have confidence in the tenant and in the tenant's story to pursue a prosecution? So the bit of data that Caroline mentioned we've obtained from the UK Ministry of Justice on prosecutions for housing offences. And this graph here shows from 2011 to halfway through 2023. You can see that there is a rise in prosecutions over the period, but if you look closely, the numbers themselves are really very low. The scale that you're looking at goes from 0 to 60, and this is cases across the whole of the UK. So maybe maximum 60 prosecutions in a year for these offences. And that doesn't seem to fit with our understanding of how common situations like this are within the sector. So the thing to take away here is having all of this law does not necessarily guarantee action. And a key part of our work is understanding what the barriers are to effective enforcement on these crimes. So the themes I've just talked about point to some of the big challenges, right, around managing the enforcement of tenant harassment and illegal eviction. And I'm going to very briefly outline factors related to the tenants and police before handing over to Caroline again, who will consider the issues with the local authorities and the courts. So for the tenants, the first step to obtaining support is to know that they have rights, that they are actually the victim of an offence. And next, they need to contact the right enforcement body. So this means going to the council rather than the police, who, as we have seen, aren't necessarily familiar enough with housing law to signpost them in the right direction. When tenants do get in touch with their local council housing team, they're placed in the position of lead complainant around the case, and that comes with a fairly high burden of involvement. They've got to submit witness statements and supporting evidence, and there's an expectation they can be called to court if the case proceeds to prosecution. And this burden is something of a problem because prosecuting these cases doesn't necessarily lead to any benefits for the tenant themselves. They likely want to be rehoused. The council's housing options team, a separate team, will be helping them with that. But that support isn't contingent on their involvement in the prosecution process. And as Caroline mentioned earlier, a successful prosecution won't necessarily lead to any meaningful damages or redress for the tenant. Moving on to the police, they're not necessarily familiar with housing law. We've seen examples of poor signposting and misdirection, telling people even experiencing housing crime that it's a civil matter and they need to speak to the civil service, which they definitely do not. They need to speak to the local council. And local authorities have also reported having problems working with the police when they're gathering evidence on cases. And this includes things like long delays in hearing back from them. So just communication issues, but also at times being asked for money to provide information. And that's not the kind of service level agreement that they ought to be working with. So at this point, I'm going to hand back to Caroline to talk more about the local authorities and the courts.
Right. So I think a lot of this now seems fairly obvious from what we've said. One of the first things is how do they identify cases? So if they're not coming to them, they won't take any action on it. And if it goes to their housing solutions people, as far as we can see, and we're doing a bit more work on this, those people won't necessarily send it off to the right team, if there is a team, to deal with it. So that's one of the issues. Obviously, there then is an issue about, okay, they know about it. Do they choose to pursue the matter? And I'm going to just move on one here to talk about a case in Cardiff, which isn't in our area, but this was actually a case that was taken last year, or yes, just over a year ago, where the lawyers for the tenant said essentially you haven't done anything. And when the case went to court, although essentially it was they agreed it, so there wasn't a full hearing and a full decision, essentially what it showed was that Cardiff had not taken any cases for more than 10 years. And essentially they had no way of taking these cases to court. So, and we think that Cardiff is probably closer to the norm than our local authority who have done these cases. So going back one, that's the first thing. Are they willing to take these cases? If they are willing, there are issues about resourcing, and that is mostly the time that they take. So even our local authority that are very active find this, they don't have enough staffing to actually take all the cases. As we've seen, there are then choices that are made about which ones go forward, and it's not always clear which ones they take forward. But there's also issues about expertise, and I think that's actually links back to the previous point, which is that even if they were willing to take it, actually most local authorities don't feel they have that expertise to take these forward. Excuse me. And then even our local authority that is very active has issues around how they put the case together. So they will generally have some internal criteria with their lawyers about whether it's good enough in terms of evidence and so on to go forward, so that leads to internal sign-off that they might not get. And then there's this huge amount of work to put together a case to go to court. So that's, you know, lots of reasons why these cases don't go to court. Even if they do get to court, there are big questions about how the courts deal with it. Essentially, it takes a long time to get into court for lots of reasons, and obviously the COVID is part of that problem now, particularly. But that, of course, means in any case that is into the courts, that you have the potential of losing your witnesses. As Kit has said, there's lots of reasons why tenants won't carry on in this. Another issue is about the actual sentencing that happens, even if it's successful. There's no guidance at the moment, although that's coming, we're told. And essentially, what happens is usually a fine, and it's usually quite small. So it's really, is it worth it for a local authority to get to that point, to get essentially a very small fine? We're talking a few £1,000s. Talked about Cardiff. You might be interested to think about, is anything happening? Well, in terms of the law, yes, you might have heard we have a new bill in front of Parliament at the moment. And this is going to make some really big changes. We're going to have an end to section 21, so it's going to be much more difficult for tenants to be evicted. Although there are going to be some new grounds that will make it possible in some cases, even when there isn't any fault by the tenant. But the bill also includes, oh, sorry, I've got a bit of a cough now, some further powers by the local authority. And firstly, every landlord is now going to have to be registered, fairly low level registration, but that should mean that local authorities are much more aware of where tenants are and who their landlords are. But important from our point of view is local authorities are going to be given a statutory duty to investigate illegal evictions. So they can't be a Cardiff and say, oh, we don't do this. They're going to have to do something. They're also going to be given the power to do a civil penalty for illegal eviction, which they haven't done, and they use a lot in the Housing Act cases. So that should make it easy, and that amount will go from £30,000 to 60,000, which, as you can see, is potentially hugely different from what happens in the criminal cases in the magistrates' courts. So, oh, sorry, I've gone too far. So I think that shows there are going to be some changes that potentially might change what happens in these cases. But I think there are also lots of outstanding points that it won't deal with. And obviously the first is tenant awareness. How on earth do they know what their rights are? Police failures, which we've talked about. Will local authorities, even if they have to do that, what's it going to really look like when they haven't got resources? One of the things about civil penalties is that the money actually goes to the local authority. So the idea is they will then have more resources. But what we're seeing in our other work is actually there are all real problems of getting the money back from the local authority. So will it actually give them more resources? So just to kind of bring this all together in terms of justice for tenants, which is where we kind of wanted to start and where we perhaps need to finish as well. What do tenants really want? Well, I suspect what they all would say is they want safe and secure housing. And is this giving them this through this process? When it goes wrong, they want some sort of damages, some sort of funding, some remuneration, which I can't say, from this process. And that's not really happening. And of course, if we think about justice, we need to think about is there some the offender, are they being punished here? Well, clearly not appropriately, I would suggest, when they're getting these tiny fines. And actually Julie, as part of our project, has been looking what landlords are saying in their online stuff about illegal evictions, and quite often they say, well, it's worthwhile to just take them money because actually that's better in terms of their practice, in terms of business, to take the money to pay for a fine than it is to then go to court and try to actually properly evict people. Anyway, I will stop at that point and we can have any questions.
Yeah, thank you both so much for such an engaging presentation. And I think your findings from the case study were really eye-opening as well. But yeah, we have around 20 minutes now. If anyone from the audience has any questions, you can just unmute and ask your question, or you can also raise your hand and I can call on you then. Yeah, Barbara, if you want to ask your question.
Hello, I thank you for a very interesting presentation. My question would be focused on the institutional landlords, because it seems that in the project you focus on the individual landlords and the balance between. This is the situation in which balance between tenant and landlord is, more balanced. How to say? Have you identified the court cases in which there were abuses related to evictions on the side of institutional landlords?
Shall I take that one?
Yeah.
So we haven't intentionally focused on smaller private landlords, it is the smaller private landlords who have been brought to our attention in our case studies. And what I believe to be the explanation for this is that larger institutional landlords have a much better understanding of the law. When this is their entire business, they are less likely to make what are arguably silly mistakes around the no fault, misunderstanding, no fault evictions or things like that. It is not to say that there is no tenant exploitation, but it's not the type of case that has been brought to our attention here. The other data that we can look back on to give us a bit of an insight is banning orders. So the 2016 legislation that Caroline mentioned at the start introduced the option for local authorities who have prosecuted a landlord successfully to pursue a banning order against that landlord. These have not been widely used. There have only been about 30 cases since the legislation was implemented in 2018. But again, what we're seeing is the vast majority of them are private landlords. There are a couple of companies there. It's not easy to tell from the cases how large the companies were, because typically it's the company and the company directors who are cited. And so that might be a sort of a one-man band or a larger company. But again, our impression is that these are the less professional end of the sector who are perpetrating a lot of this type of events.
Okay, thank you. And is there anyone else who would like to ask a question? Yeah, Wellington.
Thank you very much for your presentation. Well, I came a little bit late, probably Roberta mentioned that, but I'm just curious about how the tenants are suffering from these cases. They get to know about their rights, maybe Roberta mentioned, and I'm just curious. From your work and an amazing presentation.
It's hard for us to know that because we haven't talked to tenants. What we have been looking at through the team is what information is there available for them. So you can look at local authority websites and what does it say? Well, it doesn't say very much and doesn't help very much. So that really is the only information we've got in front of us. I think there's some stuff, if we think about the police, which is, as Kit suggests, is where people go first, because that's usually, if you've got a dispute and it's ongoing at that moment, people tend to go to the police. And as we can see, there's plenty of evidence that they don't really understand what the rights are for the tenants here.
The other main referral route we see is via the homelessness teams.
Yeah.
So there is a distinction between the private housing teams that are dealing with the private rented sector, which is what we're looking at, and the teams that deal with homelessness cases. What we often see are a referral from one to the other. So a tenant turns up because they've just been made homeless. The homelessness team gleans enough information to go, oh, maybe there is some sort of issue with illegal eviction here, and they refer it on. Which tells us really that the tenant has to experience the worst of the worst in order to get into the types of cases we're seeing, which is why we think this is so under enforced. Because no, absolutely, the tenants don't necessarily know their rights, and they're not necessarily going to be highly motivated to pursue those rights unless they're in absolute crisis.
And I suspect, I might be wrong here, I've got a sense of in some countries they're much stronger tenant organizations that you might go to. We don't tend to have those. There are a few in some cities, but there isn't that same sense of tenant organization who you'd go to naturally to ask if you've got that problem.
Thank you. Yeah, thanks for such interesting questions so far. So yeah, I was wondering if anyone else in the audience had another question that they would like to ask. Well, maybe I could ask a question. So yeah, I was just kind of comparing when you were speaking a little bit about the like the different avenues that tenants can take when they have a problem with their landlord. And I was comparing it a little bit to the situation in Ireland, because in Ireland there's the Residential Tenancies Board, and they have some powers to actually look at if an illegal eviction has occurred or different like bad behaviours from landlords. And I know in England you do have some tribunals, but I was wondering, like, do the tribunals not have any powers to look into illegal evictions? Or if not, like, do you think if these tribunals could be given those powers, like maybe it would, do more for tenants? Because a lot of the times those tribunals are very accessible to tenants, like they don't have to pay that much to go to these tribunals. So I was just wondering what your thoughts are on that.
I probably ought to say at this point, I sit or have sat in the Residential Property Tribunal in England. I'm just moving on to the Welsh one. So I should say that. But essentially, the tribunal has no role apart from RROs, so the rent repayment orders. And anything else, if it's the local authority prosecuting, then it ends up in the magistrates. And if it's the tenant taking civil action, it goes to the county court. So it's all over the place, really, in terms of who has any jurisdiction. And actually, it's the residential property has the least jurisdiction in this area. And it might make sense, and there have been all sorts of, over the years, people suggesting we should have a housing tribunal that does everything in terms of housing, but it's never got anywhere in terms of changing it. Yeah.
Okay, yeah, thank you. That's really interesting. Thanks. And yeah, if anyone else has another question, you can also type it in the chat or raise your hand. Yeah, because another thing that I was thinking about as well is you mentioned with the new act that was being brought in, that there would be some civil penalties that the local authorities could give to the landlords. But I was wondering, do you think this will actually have a big impact on stopping these illegal evictions from occurring? Because I think a lot of those things, they need to go hand in hand with also maybe like media attention, because otherwise, like a landlord who gets a huge fine in the north, people in the south might never hear about it. So landlords might not be, persuaded by that. They might think it's not a possibility that it could happen to them.
Well, I think there is a lot of relationships, certainly with some landlords, with organizations. But actually, I think the big issue in terms of eviction and civil penalties will be actually showing that there has been an equivalent of a illegal eviction under the 77 Act to the standard of the criminal standard of proof. These are used largely by local authorities where you've got, for example, a landlord who hasn't got a license. And it's a very clear difference you can show. The landlord doesn't have it, and therefore there is a criminal offence here. And it's very easy to prove that. What we're seeing with our cases, it's much more complicated and therefore much more difficult for the local authority, even if they decide to use a civil penalty, to then say, actually, there is here an offence that's happened, and they have to be sure of that to this criminal standard of proof. And I think we'll get a lot of these cases going. Then they will go to the tribunal because the landlord will be able to appeal the notice. And I can imagine a lot of hearings where it is about is there actually an offence here, which doesn't happen nearly as much with some of the housing offences because they're much simpler in terms of proving them.
So in answer to your question, Emma, I'm afraid I'm also sceptical about the immediate impact for tenants. But what we have seen and what we haven't reported on yet is looking at the decision-making of local authorities when they have an option between prosecuting or pursuing a civil penalty. They absolutely do prefer the civil penalty route for all sorts of reasons, but expediency is a really big one. So I think it is reasonable to expect, with all of the caveats that Caroline's just brought in, that those cases that do go to enforcement might go through enforcement faster, and that process might become a bit more efficient, which can, will have positive effects hopefully down the system. But I do not think it is a panacea for tenants, no.
One of the things is it essentially the local authority gives the civil penalty notice, and they have to give all the paperwork, but there's no hearing. So it is much easier from that point of view to start the process. And then it's up for the landlord to appeal it. So you can see why local authorities prefer it as a process.
Yeah, definitely. That makes a lot of sense. Thanks. So yeah, we're kind of coming to the end of the seminar now. If anyone else had any burning last questions that they wanted to ask. Otherwise, I think we can probably wrap up. So I just wanted to thank Caroline and Kate for being with us today and sharing your really interesting research. I really enjoyed your presentation. And just to let you know that the next EVICT seminar is going to take place in the new year in February. So please keep an eye out on your newsletters and on the website closer to the time. So thank you so much, everyone, for being here today, and I'll see you at the next seminar.